We're live. It's Sunday. It's Sunday. It's Sunday. But we are fresh off of a plane, back from Vid Summit, ready to go. Welcome back to the AV to the Seventh Power podcast, where we talk about all things law, true crime, a little bit of debauchery. This is going to be a very, very, very busy legal week. That is why we are having a pop-up live. I need to cover it all. There's a lot to cover. But today we are talking about ASAP Relli, Joe Tacopina, and ASAP Rocky, because there has been a latest filing that could change the game. Here's the schedule. There's going to be a hearing next week on this very case, and the judge is going to decide whether it's going to move forward. Is ASAP Relli going to have clear defamation claims against ASAP Rocky? And if you remember, at the start of this year, the criminal trial started. So we had ASAP Relli, ASAP Rocky. This whole thing played out over a 2-week trial. And I think it was February. Now we are getting ready for the defamation suit, which is going to be on the civil side. That's going to be this January. Next week on the 23rd, there is a hearing to talk about it, but it's not really looking good for ASAP Relli. So I have the latest filing. We're going to look at that. Tomorrow, good old Donna Adelson is going to get sentenced. So we have a stream already scheduled. That is at 3 p.m. So we're going to watch the sentencing. She has been found guilty for the murder of Dan Markel. Her son, if you recall, is already doing time in prison for this, but her sentencing hearing is tomorrow. Courtney Clenny has a hearing on Wednesday. It is so busy. I was like, all right, we're going to have to do a Relli stream because there's just so much going on. Also in today's stream, we're also going to talk about the Kyren Lacy thing. A lot of you guys have been emailing us about it. So we're going to take a look at the footage, the body cam footage from that in this stream as well. So a little bit of Relli, little bit of Kyren. That's a really, really sad situation. It's a vehicular homicide, and it looks like, unfortunately, he took his own life back in April. So we're going to take a peek at that as well and see the latest on all of that. But man, oh man, guys, there's so much going on. I barely had time to cover the Drake. I was like, but at the same time, that wasn't moving. So we decided to skip the Drake lawsuit, but definitely wanted to jump on ASAP Rocky, Relli, Donna tomorrow. We're going to do a full little Dirk Power Hour on Tuesday, Courtney Clenny on Wednesday, and then, of course, Letitia James and Fonnie Willis will do a full Power Hour episode on that on Thursday. A lot going on, but I am happy to be back with all of you. And going from there, do me a favor, hit the like button on your way in. It helps me, it helps you. I pop up in your feed a lot sooner when you do that, and it does project this out to so many people. I don't think we've gone live. I went live last week for my birthday, and then we did the Diddy sentencing on Friday. So very similar. Donna is going to have a sentencing hearing tomorrow as well. Okay. Let's jump right on into it. Let me see who we have in the building. Shout out to YT Johnson. He says, AV on a Sunday? Nice. Yeah. What time is it? It's taco time. It's Tacopina time. So we're definitely going to check that out. Hello to Debbie. Pretty Black Girl is in here. Fit at 58. I love that name. Good to see you. Happy Sunday. 1G Coach. It's been a minute. Tyree is in here as well. So many folks popping in on a Sunday. All the ways that you can support the show are in the description box and listed below. Without further delay, let's get into Mr. Efron's latest filing, because again, it's going to be a doozy, especially next week with the hearing scheduled for the 23rd. We definitely want to jump on into this one. Okay, here we go. This is the latest filing, and this is as of last Thursday in the ASAP Rocky and Relli situation. Let us take a look at what they have here. This is the plaintiff's opposition to defendants Joe Tacopina and Tacopina's law firm special motion to strike. So here's where we are. So October 23rd, 8:30 is the next time that they have a hearing. Here's the issue. Now, when you have ASAP Rocky and ASAP Relli, the situation is the scraped knuckles, the prop gun that was fired, and Relli is looking for some sort of compensation for his injuries. Okay. Now, ASAP Rocky was not found guilty of assault and battery, and he was not found guilty back at the start of the year. That does not mean that a civil suit wasn't going to ensue. That civil suit is here. All right. So we're going to take a peek at that. We saw that with the Kyren Reed case as well. Kyren was not found not guilty on the charges against her, but she is also facing a civil suit as well from the O'Keefe family. We did a full video on that yesterday if you have not checked it out, and we'll put a card up for those that are watching on replay. So typically what you'll see with criminal cases is that, if there is something like wrongful death or something like assault and battery, you will see these charges on the criminal and civil side, right? So that's where we are with that. Now, Relli is also suing Joe Tacopina, who is Rocky's lawyer. Okay. He's been very vocal about this, and we have a few clips to show you guys as well. So Joe Tacopina does not want to be named in this lawsuit, and he is citing anti-SLAPP, the anti-SLAPP statutes. And we'll talk about that a little bit deeper as we go through this document. This is going to be a quick one. It's only 16 minutes, and then we'll jump into what Joe Tacopina has been talking about publicly. Go to the blast in the past and check out some of the really contentious discussions that ASAP Relli and Joe Tacopina had while he was testifying. Okay, those cross examinations are riveting, to say the very least. So we'll take a peek at that as well. But Joe does not want to be listed on this lawsuit. It should be Rakeem Myers, who's ASAP Rocky, and ASAP Relli only. That's what Joe says. But let's take a look at his arguments. So, Plaintiff Terrell Efron, Relli respectfully submits the following opposition to the special motion to strike plaintiff's first and second causes of action filed by the defendants Joe Tacopina and his law firm, and joined by the defendant Rakeem Myers. So ASAP Rocky, here's an introduction for those that don't know, fired 2 shots during a verbal altercation with Relli, one of which struck Relli on the hand. The incident is on video. It was witnessed by multiple bystanders. It resulted in criminal charges filed by the LA County District Attorney. Nevertheless, in a public relations gambit calculated to turn public opinion against Relli and coerce him into dropping the incident, Rocky, through his attorney, Joe Tacopina, began giving press interviews during which he claimed that the shooting was fabricated and a cash grab, and a plain and blatant classic attempt at extortion. When Relli filed this defamation action, defendants went back to the press to call this action a publicity stunt and Relli an extortionist. When Relli filed an amended complaint to address the second round of defamation, defendants filed their motion under California's Anti-SLAPP statute. Despite years of on-point and binding case law from appellate courts holding that defendants under these circumstances are not entitled to the protection of the anti-SLAPP statute or the litigation privilege, the motion should be denied with fees and costs assessed against the defendants pursuant to this statute for 3 independently dispositive reasons. Before I get into that, this is already laughable. We're already starting off in a bad place, Relli. This is not good at all, right? Because here's what he's saying. He's saying that, although the district attorney filed charges and they were not successful at convicting Rocky, he's also saying that there were multiple bystanders that witnessed this. Now, one of the reasons why that case was so weak is because, number one, the police did not find any shell casings at the scene of the crime. And Relli went back to the scene of the crime 2 or 3 days later and magically found these shell casings. He put it in a Dunkin' Donuts bag and he bought it to the police. So it's pretty interesting that He's now claiming that multiple bystanders witnessed the event. I mean, we saw the case. We watched the case. I mean, this is not starting off well. Let's just say that. Okay, so he says 3 reasons why the motion should be denied. Let's go with the first one. First, false accusations that a person committed a crime, here extortion and assault, are not protected by California's anti-SLAPP statute, which applies only to constitutionally protected speech about a public issue. Defendants' minimal efforts to suggest that their statements are relevant to a public issue because ASAP Rocky and his wife are famous are contradicted by controlling case law cited below. Second, defendants do not appear to dispute the merits of the plaintiff's claims at all. They offer no evidence with their motion and do not attempt to argue that they did not make the alleged misstatements or that the statements were true. Plaintiff, for his part, has submitted clear evidence that the shooting happened and the defendant's statements were knowingly false and defamatory. This unrebutted evidence more than demonstrate the minimal merit required to defeat a motion under the anti-SLAPP statute, which is not designed to guard against legitimate claims. Third, defendants base their entire motion on the application of the litigation privilege, but as a matter of black letter law established for decades through multiple binding appellate rulings, the litigation privilege does not apply to statements made by attorneys outside of the court to the press. Okay, so they're citing a few cases. Only cursory research would reveal these controlling cases, none of which reference in the defendant's moving papers, and the defendant's own law firm has published an article on the subject. It is inconceivable that defendants were unaware of this dispositive case law before filing the motion. Because the motion provides no basis for this court to grant it under controlling precedent, plaintiff respectfully submits that it should be denied and costs assessed against the defendant. Now, that's the other big thing when it comes to this lawsuit, is Relli is trying to keep costs low, and the judge did warn him a few weeks ago, hey, if you continue, maybe you should drop some of your claims, because if you lose, you will have to pay these attorney fees. And Joe Tacopina charges like $2,400 an hour. So imagine if Relli loses this case and has to, he's asking for money from Rocky, but imagine if he has to pay those fees. Now, this is very interesting because over the past few weeks, we're seeing a lot of celebrity lawsuits go down in flames. So you remember the Cardi B situation with the security heavy chick, the security guard, right? The former security guard who is now going to law school. That, in many respects, can be looked at as a frivolous lawsuit. The plaintiff in that case was not successful in, seeing what happened and getting her $24 million, right? She took her chances in court anyway and lost. I don't know if she had to pay for those attorney fees, but Cardi B is highly litigious. We saw it with her and Tasha K. And guess what? Tasha K had to file for bankruptcy, but had to pay those fees to Cardi B, right? So Relli has to tread very carefully here, right? He really does, but let's keep going and go to the facts. So on November 6th, 2021, Mayers requested that Efron meet him in LA. Okay, so Rocky requested that Relli meet him in LA. Relli, hold on, that's a paragraph. Upon arrival, Rocky initiated a verbal altercation, brandished a handgun, and fired multiple times, striking Relli in the hand and causing injury. Rocky then fled the scene on foot. The incident was witnessed by bystanders and captured on surveillance video. On August 10th, Relli filed a civil action in the Superior Court of the State of California for the County of LA. In that action, Relli alleged that Rocky shot him following a verbal altercation as set forth above, after which he sought medical attention for his injuries. On August 15th, Rocky was criminally charged with 2 counts of assault with a deadly weapon. On or about September 16th, Tacopina, as counsel for Rocky, gave an interview to TMZ that was published in an article titled ASAP Rocky, I Never Shot Him. It's an extortion attempt. Tacopina is quoted as stating, amongst other things, that the assault claims asserted by the plaintiff were a cash grab, a get-rich-quick scheme, and an extortion attempt. That plaintiff had threatened to make false accusations, that plaintiff wasn't hit by bullet fragments, and that no shot was even fired. On or about September 16th, 2022, Tacopina gave an interview to the Rolling Stone, in addition to TMZ, that was published in an article titled ASAP Rocky Lawyer Says Jealous ASAP Relli Fabricated the Shooting in an Attempt at Extortion. Tacopina is quoting, saying, amongst other things, that ASAP Rocky is a victim of a failed shakedown and fabricated shooting accusation orchestrated by his jealous former friend, ASAP Relli. Rocky didn't shoot Relli by any stretch. The incident is a false scenario and a plain and blatant classic attempt at extortion. Rocky tried to spin the confrontation into a shooting claim. That plaintiff was engaged in an extortion, and that plaintiff tried to attack Rocky, and he punched some other guy in the face and knocked his teeth out. About 10 days later, Joe Tacopina gave another interview on a radio show called Bernie and Sid in the Morning. In the radio interview, Tacopina stated the plaintiff was making a clear extortion play and that he had proof of extortion. Following the Rolling Stone article, the TMZ article, and the radio interview, and subsequent republication of Tacopina's quotes by numerous other news organizations, plaintiff received a repeated and ongoing death threats. Oh, come on, Relli. Okay, Relli is saying that he has received many death threats because of Joe Tacopina giving these interviews. All right. Interesting. He was effectively blackballed in the music industry. The business he had been developing failed, and he was forced to move his family out of the state to avoid unrelenting negative public scrutiny. On September 11th, 2023, plaintiff filed this action, asserting claims for defamation against the defendant for false and defamatory accusations made in the Rolling Stone article, the TMZ article, and the radio interview. After filing this action, Tacopina gave a second interview to TMZ, in which he was quoted as stating that this lawsuit is a publicity stunt and plaintiff is an extortionist. Plaintiff then filed an amended complaint based on the subsequent defamatory statements by Tacopina, and defendants filed this motion seeking dismissal under California's Anti-SLAPP statute. So Joe Tacopina wants this case thrown out. It's just like, hey, I gave an interview. Rocky was my client. I talked about it. It's defamatory. The things that were mentioned are not true. And lawyers can represent their clients and give interviews. Relli is suing Tacopina, bringing him in as a co-defendant, right? Because of what he's saying. Now, Tacopina is just like, listen, I was doing my job. So we're going to file a motion to dismiss this against me. You and Rocky can duke it out, but you're not going to keep me on as a co-defendant, right? So he's using the anti-SLAPP statute, and that really protects First Amendment rights. But here's the thing. I don't know if Relli's going to, I don't know. I don't know if Relli's going to win. I don't think he has a strong argument on this so far. We're already halfway through and we're about to go into the legal standard. He might have some claims against Rocky, but against Joe Tacopina, I don't know. I don't know. Let's keep going for the legal standard. The California Code of Civil Procedure provides a cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the U.S. Constitution or the California Constitution in connection with a public issue shall be subject to a special motion to strike. unless the court determines that the plaintiff has established that there's a probability that the plaintiff will prevail on the claim. The statute was enacted to encourage continued participation in matters of public significance, and that this participation should not be chilled through abuse of the judicial process. Under this statute, an act in furtherance of a person's right to petition or free speech under the U.S. or California Constitution in connection with a public issue was used in this statute here, and it includes a couple of things. It looks like there's 4. 1, any written or oral statement made before a legislative, executive, or judicial proceeding. We don't have that here. 2, any written or oral statement in writing made in connection with an issue under consideration by review by a legislative, executive, or judicial body proceeding. So we don't have that here. 3, any written, same thing, or oral statement in writing made in a place open to the public or public forum in connection with the issue of a public interest. Okay, possibly 3. Or 4, any other conduct in furtherance of the exercise of the constitutional right to petition, right of free speech in connection with a public issue and issues of public interest. I guarantee you he's going to go into that it's not an issue of public interest, but let's keep going. Courts proceed under a 2-step process to determine whether an action should be stricken as a SLAPP. First, the court must determine whether the defendant has made a threshold showing that the challenge cause of action arises from an act in furtherance of the right of petition or free speech in connection with a public issue. Second, the court must determine whether the plaintiff has demonstrated a probability of prevailing on the claim. As to the second prong, the court accepts the plaintiff's evidence as true, and thus the burden of establishing the probability of prevailing is not high and requires only minimal merit. Okay, that looks like it's cited from a case from 2023. What's their argument? It looks like making false accusations regarding criminal conduct is not a protected activity under the anti-SLAPP statute. I knew it. I knew it. The defamatory statements in this action have no relation to the defendant's right of petition or free speech. Okay, it looks like he's citing a Weinberg case from 2003. In Weinberg, the defendant publicly accused a fellow coin collector of theft and, after being sued for defamation, filed an anti-SLAPP motion. The Court of Appeals affirms denial of that motion because it was well established that the defamation of an individual is not protected by the constitutional right of free speech, and statements accuse plaintiff of criminal conduct make them defamatory on their face. The court noted that holding otherwise could mean that wrongful accusations of criminal conduct, which are amongst the most clear and egregious types of defamatory statements, automatically would be accorded the most stringent protections by law, without regard to the circumstances in which they were made, a result that would be inconsistent with the purpose of the anti-SLAPP statute and would unduly undermine the protection accorded by the statute. Defendants superficially suggest, without declarations or other evidence, that the statements are subject to protection because they were made through a publicly accessible website, such as those operated by TMZ and the Rolling Stone, and that Rocky is a world-famous rapper who also happens to be in a romantic relationship with one of the most famous women in the world, Rihanna. But after being famous or making statements through widely distributed news outlets does not automatically render speech relevant to the public interest. I knew it. I knew he was going to go for that. I knew he was going to do that. Okay, they're citing a few cases here. Here's another one. For example, in Albanese, a celebrity stylist sued a television personality for defamation arising from public statements suggesting that the stylist had stolen certain luxury goods in the past. The defendant moved to strike pursuant to the anti-SLAPP statute. In determining whether the speech related to a public interest, the court noted that case law does not stand for the broad proposition that anything said or written about a public figure or a limited public figure in a public forum involves a public issue. See, that's the thing. Is it truly a public issue, right? He's defending his client. He's doing standard interviews. Standard. Relli is saying, this is defamation because what you're saying about me is not true. But at the same time, Rocky wasn't convicted on those assault charges, right? I'm going to take a quick little super chat break. A few of you guys have popped on in. Shout out to Nurse Janice, been with me for 17 months. Good to see you, Nurse Janice. She says, miss you all. Had to hear this. Keep up the good work, hun. Thank you so much, Nurse Janice. Great to see you today. Shout out to Miss Ashley RN with the 2. Says, hey, y'all, sending good vibes from the Caribbean. Thank you so much. Hope you are enjoying your vacation. It sounds like you're on one. Let's keep going on this one, guys. And then we're going to look at Joe Tacopina on VLAD TV so we can see how he does interview, right? And then we'll go back to back in the past with Joe and Relli, because you could really see that Relli is coming for blood when it comes to Joe Tacopina. But I don't know if Joe might get taken off as a defendant as I'm reading this. It's not very convincing. The assertion of a broad and public interest is not sufficient. Rather, the focus of the speaker's conduct should be the public interest, not a private controversy. The court affirmed the denial of the anti-SLAPP motion because even if the plaintiff is rather well known in some circles for her work as a celebrity stylist and fashion expert, there's no evidence that the public is interested in this private dispute concerning her alleged theft and unknown items from the defendant. Or Dolce & Gabbana. Interesting. Defendants' 2 case citations do not support in their motion. Okay, so it looks like Joe Tacopina had 2 cases that they cited. The court held that the Communications Decency Act of 1996, which provides that no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider, precluded liability, and thus the anti-SLAPP motion should be granted. Okay. This action, like Albanese and unlike Hall, arises from a purely private dispute without broader application to free speech or the public welfare. Relli was shot by Rocky and then repeatedly defamed. Whether a subset of the public may be curious about the occurrence because of Rocky's fame or the fame of his wife does not implicate constitutional speech about public interest. The motion should be denied for this reason alone. Next, plaintiffs' per se defamation claims are meritorious, and thus the anti-SLAPP statute does not apply. The evidence demonstrates that Relli was shot and then defamed. The elements of defamation are 1, a publication, 2, that is false, 3, that is defamatory, 4, it's unprivileged, and 5, has a natural tendency to injure or cause special damages. For the purposes of this motion, the court must accept as true all evidence favorable to the plaintiff and assess the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. Plaintiff's evidence submitted herewith satisfies every element of defamation, and defendants do not appear to meaningfully dispute any of these factors. Let's go through, the elements again. So the publication. Tacopina's statements were made to journalists and published through TMZ, Rolling Stone, and other media outlets. Defendants do not contest the publication of the statements at issue and tout them in the motion. Okay, so they're not denying it. Tacopina's like, yeah, I did those interviews. I was there. Next, falsity. The evidence demonstrates that Rocky contacted Relli to meet him in LA on November 6, 2021. Relli met with Rocky, who initiated a verbal altercation, brandished a handgun, and fired 2 shots. one of which struck and injured Relli. Rocky then fled the scene on foot. Multiple eyewitnesses, why does he keep saying that? Multiple eyewitnesses witnessed the events, and most of the incident was captured by surveillance cameras, including Rocky shooting Relli. Now, I remember this because we had a few people that were on the stand. They never said that they saw it happen. So I'm really confused about him talking about multiple eyewitnesses. You have the person that called 911, and then you had this other woman, I think she was Australian. She looked out of her window and saw the commotion happening, but then it comes out on cross-examination that she was high. She had been smoking the grass, and that is one of the witnesses that he claims was an eyewitness. She didn't necessarily see the altercation. She looked out and saw people running around and all of that. And then she is the one that called 911. So when he says multiple eyewitnesses, who is he talking about? So Relli suing Tacopina here is very interesting. But multiple eyewitnesses? Didn't come out in the criminal trial, at least. Thereafter, in the press, defendants made statements about the incident and plaintiff that were false and defamatory on their face, including that one, no shot was ever fired. No shot was even fired. Two, plaintiff wasn't hit by bullet fragments. Three, plaintiff fabricated and made up the story in a get-rich-quick scheme. And four, a plaintiff is engaging in a plain and blatant attempt at extortion. So these are the statements that Relli is saying are false. So let's break them down. The first one, no shot was even fired. Well, if you have video evidence that something was fired, I mean, it's a prop gun. That's on video. So Relli is saying here that that's not true. Right? Second, Relli wasn't hit by bullet fragments. Tacopina said that. You see that quote? He's saying that's not true. I was hit by bullet fragments. I don't know, because that was the other thing. He had the pictures of the scrapes on his knuckles. He went to the hospital a few days later. The whole thing was super fishy. He's saying that that's not true. Next, Relli fabricated and made up the story in a get-rich-quick scheme. Now, he's saying that that's not true. Well, remember those text messages that came out during trial? There's a few text messages that were shared. And Relli was saying to another person that he's trying to get this ninja's money. I remember that specifically. He said it. He's trying to get his money. So if you're thinking about the defense team and, I'm not sure who Rocky has retained to defend him in this action. And I wonder if Tacopina can do it if he is a defendant as well. So it might be another attorney. Now, he is saying that it's not a get-rich-quick scheme. But the defense team can use some of that evidence that came out in that trial to defend this action. And there are text messages where Relli himself says that he wants to be paid. He wants to be compensated for his injuries, right? Said in a much more colorful way. But there's proof of that. So I'm having a hard time. I'm stuck on number 3. Hi, Kelly Kell, my favorite 3L. So there was a guy that flew out and talked about it. And those were shared. Those were shared. Next, number 4, a plaintiff is engaging in a plain and blatant attempt at extortion. See, that's the same thing. I think he has another problem with number 4 here. Because you're saying that these 4 pieces or these 4 things that Tacopina said are not true, and that's defamation. But we have proof that you did indeed say those things. I mean, you said it. So this attorney is saying these statements are false in the light of the unrebutted evidence demonstrating that Rocky did in fact shoot Relli. Okay, I think they have that. I think they have that. He shot at, right? And that's on camera. But here's the other thing with that surveillance footage, we couldn't see everything. It was like cut off. You can only see because of the angle, the way it was pointing down. You could see some of the interaction, but it wasn't as clear as day. It's not as clear as they're making it out to be in this document. Next, let's go to the defamation. A statement per se defamatory. A statement is per se defamatory if it charges any person with a crime or tends to cause damage to the individual, his profession, or his reputation. Oh, here we go. Really, I can see it coming. Defendant's statements falsely accused Relli of, among other things, making a cash grab, an extortion attempt, false criminal accusations, a plain and blatant attempt at extortion, and a clear extortion play. Defendants also falsely stated that Relli tried to attack Rocky and punch some other guy in the face and knocked his teeth out, suggesting a crime of assault. These statements are plainly defamatory under California law. We'll see there's another problem here, guys. Remember, he did hit another one of the ASAP guys, right? He did hit one of those guys. It wasn't 12E, it was the other one. I can't remember off the top of my head. It wasn't 12E, but 12E came out to testify to it. The one that got hit was not involved in that trial. But like, that actually happened. They testified to it. It's so crazy. All right, they're citing a few cases, a 1996 one, a 1991 one, a 1978 one. Let's go to unprivileged. As set forth in the immediately following section, defendant's statements are not protected by the litigation privilege or any other privilege. Injury. The defamatory statement set forth above destroyed Relli's career and reputation in the music industry. And among the general public, he was moved out of state to avoid continuous death threats. Injury to Relli's public reputation, professional standing, safety, and livelihood are well-recognized damages in connection with a defamation claim, especially those arising from false accusations of extortion. Defendants make no effort in the motion to rebut any of the factors above, which establish a meritorious defamation claim, and thus the anti-SLAPP statute has no application. I think this is a weak argument. Next, the litigation privilege does not apply. The defendant's public statements to the press. There's a quote here. It says, litigation privilege of Civil Code Section 47 pertains to any communication made in judicial or quasi-judicial proceedings by litigants or other participants authorized by law to achieve the objects of litigation and that have some connection or logical relation to the action. Okay, that comes from a case from 2016. Specifically as to the public statements by attorneys outside of court, California courts have repeatedly held that any attorney who wishes to litigate his case in the press will do so at his own risk. Holding that litigation privilege does not apply to public statements uttered outside of the court and not during any legal proceeding, including statements to newspaper and television reporters who had no interest in the action. All right, so he's basically arguing here that he doesn't have any protection. Tacopina doesn't have any protection because, he's an attorney. He represented Rocky at the time and made some public statements to news outlets or whatever regarding the case. He's saying that privilege, litigation privilege, doesn't apply to him. I mean, we'll see how the judge rules next week during this hearing, but I really want to see what's going to happen. He cites a Rotman v. Jackson case, an attorney who was hired on behalf of a minor to negotiate a settlement with Michael Jackson for alleged abuse. When a medical report was leaked revealing the allegations, Jackson and his attorneys organized a press conference at which the defendants not only denied the charges against Jackson, but made countercharges that Rotman, the attorney, and his clients had knowingly and intentionally made false accusations against Jackson in order to extort money from him. This does kind of remind me of the Jay-Z Busby Diddy stuff from the start of the year as well. Because that's the thing with these celebrity cases, right? There's a lot of defamatory words being thrown around, charges, or not even charges, claims of defamation. But like, you saw it with Jane Doe, Tony Busby, and Jay-Z's team at the start of the year. That lawsuit got like quashed. It was thrown out because Tony Busby didn't do his footwork. And it came out that, the woman was actually not being truthful. Relli's hanging on to this one though. He totally is. Hi, Variant. It's good to see you. I'm happy you got the notification this time. It was ASAP Ills. Thank you, Danny. Thank you. I think it was ASAP Ills. Thank you so much for that, because it was killing me. I was just like, what was his name? That was so long ago. Anyway, back to this. The attorney sued Jackson and his counsel for defamation and defendants asserting litigation privilege. The court held that the litigation privilege did not apply because it is limited only to statements that function as a necessary or useful step in the litigation process. It is not enough to say that the content is related in some way to the subject matter of the litigation. While a person's motives for litigating a dispute may include a desire to be vindicated in the eyes of the world, a result which litigation may achieve, this is not what is meant by the term objects of litigation for application to the litigation privilege. A party's legitimate objectives in the litigation are limited to the remedies which can be awarded by courts. The court in Rothman unequivocally rejected the argument that litigating in the press, even for a celebrity, is protected activity for lawyers or litigants. I'm not reading that long thing there. I'm not doing it, y'all. Next, courts have repeatedly held the same under similar circumstances in which lawyers and their clients have defamed a litigation opponent in the press. Holding that litigation privilege does not apply to statements made by an attorney in a press release and a tweet to publicize the alleged misdeeds of the plaintiffs, namely false allegations regarding a pending FBI investigation. That comes from a 2017 case, couple holdings. In this case, defendants are alleged to have made multiple false statements in non-parties, so including TMZ and Rolling Stone, outside of a court and before this litigation was even filed, claiming that the plaintiff is a liar. Relli, you a liar. That the shooting did not happen, Relli. And that Relli, you fabricated the incident to extort Rocky. After this action was filed, defendants doubled down by stating to TMZ that plaintiff is an extortionist. These statements are not subject to the protection of litigation privilege as a matter of settled law because they were never designed to achieve the objects of the litigation or function as a necessary or useful step in the process, but rather sought only to influence public perception and injure Relli's reputation. Oh, Relli. He's just like, you ruined my reputation, Joe. Why'd you have to do that to me, Joe? You called it a cash grab, Joe. It's not a cash grab. Rocky shot me. He shot me. He has to pay. I want this ninja's money. That is what he said. It's so crazy to me. All right, let's keep going here. All right, Relli is entitled to attorney's fees and expenses pursuant to section 42516B1. This section of the anti-SLAPP statute provides that if the court finds that a special motion to strike is frivolous or solely intended to cause unnecessary delay, the court shall award costs and reasonable attorney's fees to Relli prevailing on the motion pursuant to section 128.5. That section provides that a trial court may order a party or a party's attorney or both to pay reasonable expenses, including attorney's fees incurred by another party as a result of actions or tactics made in bad faith that were frivolous or solely intended to cause unnecessary delay. Frivolous means totally and completely without merit for the sole purpose of harassing an opposing party. Joe Tacopina's motion is frivolous because the court cannot grant it as a matter of law without deviating from the directly applicable, controlling and binding appellate court rulings, none of which is disclosed in the motion. Defendants cannot demonstrate that false accusations of criminal behavior or are constitutionally protected under the Weinberg and similar cases. They have done nothing to dispute Relli's meritorious legal claims arising from per se defamation under California law. Instead, they based their entire motion on the application of the litigation privilege. But black letter law in California expressly provides that statements by attorneys outside of the court to the press are not protected by litigation privilege. Indeed, minimal legal research is required to determine that Tacopina's statements to the press are not protected by litigation privilege under California law. Review of Counsel's own publication turns up a December 2023 article by the partners at Gordon, Reese, Scully, and another name I can't pronounce. It looks like it's a law firm, acknowledging the general rule that the attorneys are not entitled to the protections of litigation privilege for statements made outside of court to press. But Colorado adopted a safe harbor expansion to the rule in class actions, which has not been adopted by California and would have no application here anyway. The only plausible reason to file an unwinnable motion is to cause unnecessary delay and expense, either of which support awarding costs of opposing the motion to Relli. For the reasons above, Relli seeks an award for attorney time at each attorney's ordinary hourly rate directly relating to the drafting of this opposition. That's what it is. Remember what I told you. Relli is really worried about attorney's fees right now. So Joe Tacopina filed this motion, was just like, hey, number one, take me off as a defendant. And number two, your claims against Rocky, you need to be focusing on that, not what I said to the press. And at the end of the day, I'm protected, right? I'm protected with what I say to the press because that's my client. I was doing my job, right? So Relli was warned by the judge that, hey, you can proceed with this lawsuit, but here's what happens. If you lose, you will have to pay Rocky's attorney's fees. It happened to Tasha K, guys. And we know Joe's rate is $2,400 an hour. So, he is just, if this motion proceeds, he wants to make sure that, hey, my attorney's fees are going to be paid too. So Relli's in an interesting position here. Defendant's motion to strike is meritless under long-established precedent and should be denied with costs awarded to the plaintiff. So there is Relli's attorney's signature. And there's a hearing on this next week, guys. So on the 23rd, we will be back here to see what happens. That's really where I think it's the final hearing before trial too. And we even get to see if this case is going to proceed. So it could be thrown out. A lot of people are speculating that it could be thrown out. A lot of people have been talking about that. So we'll see what happens. But October 23rd is the next day that we will be in court to figure out what happens with that. Now, here's the interesting thing. Do you think that Joe Tacopina stopped talking to people in the press? The answer is no, because he was on VLAD TV a couple months ago, right after this case ended, and he broke all of this down with VLAD. So let's take a peek at that, because he was not going to stop. He knew that this civil suit was coming, but Joe Tacopina is still talking to the press. He's still doing interviews. It did not stop.
Okay, so the trial starts, but leading up to the trial, and you've touched on this, ASAP Relli claims to be the victim. He claims he got shot in his knuckles, which already sounded like
how he survived
BS.
that life-threatening injury. It's a miracle. I don't even know how those two knuckle scrapes, how he didn't bleed out right on the scene, but somehow he didn't. He survived it. It was amazing. It's a miracle.
Well, and look, a lot of people have cooperated on people. Like that's not a rarity in this world. But Relli not only cooperated, but he actually went back to the crime scene on his own and found some bullets he claimed were the bullets from the discharge of the gun, which, like you said, 7 cops could not find.
The exact same spot that he found.
And that seemed crazy to me as well.
And then when you understand who Relli was, I mean, he was a witness that, as I told this jury in my summation, ladies and gentlemen, you had a front row seat to the worst witness in American jurisprudence history. I mean, I bludgeoned him. And honestly, one of my kids who have no training in the law could have done the same thing. He was an easy witness to tear apart. He perjured himself. He admitted perjuring himself. He got caught in one lie after the next. I mean, to the point where the jury stopped looking at him. At one point, when the jury stops looking at the witness, it's over. But one thing he lied about was, before November 6, 2021, had you ever shot a gun, sir? No, I didn't have my license. So you never shot a gun. How about, did you ever shoot a 9mm like Glock, semi-automatic? No. Okay. All right, let me just narrow this down to make sure we're on the same page. Before November 6, 2021, have you ever shot a semi-automatic gun at a shooting range? He goes, no. I said, no? And he got all belligerent and arrogant like he did throughout the whole testimony. He goes, you heard me? No. I go, I heard you. No. Okay. How about this?
I'm sorry. If this goes to trial, guys, it's going to be fun. I kind of miss watching Tacopina because the internet was interneting and somebody had found an image and sent it to Joe Tacopina of Relli at a shooting range like a month before. It was amazing. He's like, yep, how about this? And that was it was really good. It was good when we watched it. But like Relli did perjure himself a lot. So think about the fact that Joe is not afraid. He's still going and doing these interviews. He's on VLAD talking about it right now. So if this goes to trial, I think it's going to be a circus and Relli might lose.
Play a video of him in a shooting range on October 19, 2021. Boom, 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 boom. The prosecutor, now you see in the back of the guy, prosecutor, it was like it was choreographed perfectly. Prosecutor goes, how do we know that's him? In front of the jury, inappropriately. And at that moment, Relli goes, shoom. It was like, thank you, Relli. It was like the jurors started actually laughing because he happened to turn around the video at that second. And then you see these shell casings popping back over his shoulder. 9mm shell casings. October 19th before November 6th, 3 weeks before. I said, you just told this jury you never fired a gun before November 6th, let alone a 9mm. Then he goes, a 9mm semi-automatic Glock. Then he goes, I said, except at a shooting range. I go, were you here 43 seconds ago when you just said absolutely not? He's like, I didn't say that. I said at a shooting range. I'm like, you think so, huh? I played, the beauty of this thing being on television is I got to play back his answer. Then I said, well, where was the shooting range? Because, what the prosecution was going to argue was that was in New York or New Jersey. Mm-hmm. And even if he did do that, so what? Because he had to fly back commercially to Los Angeles and he can't carry shell casings on a plane. So it doesn't really amount to a hill of beans. I was like, really, where was that shooting range? And he said, I don't know where. I think New Jersey. And the prosecutor, again, completely inappropriately, stands up in the middle of that, says, can we have a stipulation that shooting range is not in California? And I go to him, how would I know where it is? I'm not stipulating to that. And so the witness, but that was the key to the witness. The witness then jumps in and says, all I know is that was not in Los Angeles or California.
What?
I was like, oh, okay. Then now you know that, right? I said, okay. That was it. But it was bad enough evidence that he lied about shooting. That was a Friday. I wasn't done with the cross. My son, Chris, who works for the Florida Panthers as a data analytics manager, has zero legal training. He was obsessed with this case. He went on the internet and looked at every gun range in Los Angeles.
Wow.
And he watched videos of every gun range. He went on the websites. The Los Angeles Downtown Gun Club, which is about a 12-minute walk from the courthouse, has a shooting range, and it's the exact same shooting range that this guy, Relli, was shooting that gun in.
Wow.
You can see the way the infrastructure is, the way the targets are, the numbering above the targets. He said, Dad, that range was in LA that he was shooting. I'm like, Chris, how do you know that? He goes, look. And he sent me a video. I'm like, okay, be back. I took a car. I drove. Every red light I went through. I was going about 95 in LA. I went to that gun range. And I said, see this video? Is this your place? The guy's like, yes. I was like, wow, thank you. Soon enough, when I got back, and I was my trial team, I was like, guys, meeting immediately. This was Saturday. All we did was work. I said, we are going to destroy this guy now. He lied. He perjured himself again, but about something really important. That was in LA, that gun range. So he had access to those shell casings, and there's no evidence that he ever left LA. Someone posted on the internet, everyone has the internet access now. I think it was on X or something like that, but some person who I have no idea who it is posted a picture of the LA Gun Club, and it wasn't my son, it was somebody independent because I didn't want to bust it out. I didn't want him to get a heads up. and the picture of the video of Relli. And they said, why would Relli lie about that? It's the same club. And they tagged Relli, tagged Rocky, tagged me. I'm like, oh, shit, he knows now. This is at 2 o'clock in the afternoon on a Sunday.
I remember that.
2:10, Relli calls the district attorney's office because we got this on Discovery. And he said, oh, I was going through my phone because I want to make sure all my testimony was accurate.
I remember that.
I was going through my phone and I realized I think that gun club was in Los Angeles. It's literally 10 minutes after he's tagged on the post that came out. He knew what was happening about that. So Monday morning was a fun morning for me, Vlad. It was a really fun morning. I go, hey, let's talk about the gun club. You sat here and told us you knew it wasn't LA, maybe New York, New Jersey. How about now? He's like, well, I went through my phone, and he tells the prosecutor, I went through my phone and I realized, oh, that was in Los Angeles. I go, is that what happened? You just went through your phone because you didn't want to be wrong in your testimony? How about your other testimony? Did you correct any of that? The part where you said you invested money in a big real estate venture in Miami in a building, but you don't remember how much you invested or in what building it was. Did you go figure that one out yet in your phone? No. This one you figured out, right? It had nothing to do with the fact that at 2 o'clock you were notified via Instagram being tagged that this gun club was the same one in LA that's them on the video, right? It had nothing to do with that. He's like, no, I said, and coincidentally you called the district attorney 10 minutes later, right? Some of the jurors were laughing, literally.
That's crazy, guys. It really is. It really is. I feel so bad, like to an extent for Relli, but the fact that he's still pursuing this civil case after all of that, I forgot about some of the things he lied about. Like that's where one of our merch shirts come from. He like Joe Tacopina asked him a question and it was on cross-examination. So you're thinking you're going to get yes or no answers. In one of his answers, it was yes, no, maybe, I don't recall. Like it was just bad. It was just bad. So to remind you of what type of witness Relli is, we're going to look at this. And it's so funny because on the side of other videos, I can't believe that they gave him Donkey of the Day at the Breakfast Club. Relli's did suffer a little bit of reputational damage. I'm not even gonna lie. But at the same time, did he do this to himself? Let us look at this masterpiece of a cross-examination. Let's take a look at it.
Good morning, Minister. Speaking of saying, you always said 3 or 4 shots. You talked about Wally Sajid the other day. You remember Wally?
I don't remember. I mean,
you don't know who Wally is? Sorry?
Let's go, Mr. Tacopina, let's go.
Well, we're going to go when you answer my question. You know who Wally is?
I do.
Okay. In fact, you told Wally.
Let me adjust the volume.
You shot him 5 times, right?
No, I didn't.
You didn't say it?
No, I didn't.
And by the way, speaking of Wally, last Thursday was my first day of cross-examination of you, and I asked you about a statement you made to Wally that morning.
The question is maybe true that morning. Status of you mean the morning
The morning of the
cross-examination?
examination, yes, sir. The morning of the examination last Thursday, I asked you questions about Wally. Two statements you may have made to Wally, which you denied. At the lunch break, Mr. Efron, you called Wally, correct?
I called him after everything because, I mean, you guys got y'all whipping up lies over here. None of it, you have no evidence to back that up.
You're not answering this question. He's talking about the lunch break. Ask it again.
And I'm not, and I'm
Mr.
allowed.
Efron, wait. Ask the question again.
After Wally's name was brought up on cross-examination by me, the statements you made on the recordings that you say were fake, you called Wally.
He
That's
didn't
a
answer.
compound question,
It
there are
is.
3 questions.
All right. You were inquiring about whether you made a phone call at the lunch, on the lunch
He
break
was lying.
following your, beginning your
Yes,
cross-examination?
sir.
Do you understand the question? All right. Did you call Wally during the lunch break?
No.
Did you call him after court?
Yes, I did.
Oh. And why'd you call Wally?
Because, I mean, you guys is just lying, lies after lies. You can't back it up. These guys,
We can't back it up.
I mean, you can't. You can't.
Did you hear the tape recording? Did you say fake?
All right. Stop.
This one is
Ask another question.
Stop.
I guess we'll see about that, right?
Your Honor, sustained. Can the court instructed previously, and this is editorializing, Mr. Lennon is not doing that in his draft?
Right.
He's right.
But I
It's
know,
like
you
night
wouldn't
and day.
just say,
I don't
made up
understand
answers.
what you're saying.
Don't editorialize.
Then you should strike his answers, Your Honor.
They are not responsive.
They are not responsible. Anyway, so you called him because we were presenting fake evidence to you?
Yes or no?
I don't know, man. It's just,
Why did you call him? Mr.
because
Efron?
you guys just keep playing fake audio to me, like fake stuff. I never said none of that to him. It doesn't even make sense. It doesn't fit in with this case. You're trying to slip it in.
Okay, stop. All right, you answer the question.
So that's why you called, wow.
I mean, you guys are saying I'm cool with him and I got his number and he's making up fake lies. That's like, he didn't even answer, so I don't even know what are we talking about. He did not answer. What are you gonna say? He answered and make up another spoof call?
You're done.
Motion to strike is non-responsive.
Long
Strike his own
answers.
testimony, okay.
Yeah, the entire answer is non-responsive.
Your Honor, counsel is editorializing indicating what I'm moving to strike. I'm following the evidence code of the state of California. Yes, the counsel follows as well, and not editorialize as to why I'm asking things to be stricken. It's improper.
Can't you just stop squabbling? Just stop it.
I'm not swallowing.
No, this is a no
Squabble
squabble
up.
zone.
A
Stop it.
no squabble zone.
Okay. You asked about text to Rocky and to his manager John after the incident, it was 21. Remember being asked that by Mr. Preslon a few minutes ago? Text after the incident saying, you tried to kill me.
Say that again, I don't get what you're saying.
You asked about text messages by Mr. Preslon right here, just a few minutes ago. After the incident, where you text Rocky and his manager John saying you tried to kill me. You remember being asked those questions by Mr. Preslon?
I'm sorry, I don't get what you're saying. It's not clear. It's double negative. I don't get what you're saying right now.
It's a double negative.
It's not really clear, you know what I mean? I'm trying to answer something I don't understand anymore.
Do you remember? I'm gonna break this slow. Do you remember?
We got all day.
Do you remember being asked by Mr. Preslon a few minutes ago today about text messages you sent
Okay.
with me so far? Are you with me so far?
Yo, you're annoying, bro. Just come on.
Are you with me?
We didn't even get to the case. What are we doing here?
Are you keeping up? Stop. Are you keeping up with the question?
I can't keep up with him. I can't take him serious.
No. You got to answer the questions. He asks the questions. He's beginning to ask you a question. He just wants to know if you're keeping up with him. Just ask the whole question.
Sure. You recall being asked by Mr. Preslon a few minutes ago about text messages you sent to Rocky and his manager after the incident saying you tried to kill me.
Yes.
Oh. And you were also saying you tried to kill me. During that same time, you were sending messages saying, I'm gonna get that N's money, right?
Bro, what are we talking about? We talking about assault or lawsuit? Like, you keep trying to bring
He's
the
asking,
lawsuit.
he's asking you a yes or no question. Listen to the question
I
and
don't
if
understand
yes, no,
these
I don't know, or
questions.
I don't recall. Go ahead.
At the same time you were saying that, you were also sending text messages saying, I'm gonna get that N's
I
money.
don't recall.
You don't recall? You don't recall seeing those messages up here?
Seeing what messages? You're not, like,
You have that message.
Your Honor, I previously advised the court that I had a meeting.
Do you need to go?
Yeah, the court just advised the jury that my meeting.
Yeah, Mr. Lewin has to leave. He's got an unavoidable commitment. He tried to postpone it. He couldn't, so he's going to leave now. He'll be back at 1:30, right?
Yes, I will, Your Honor. Yes, I'll be back. Thank you.
You promise, John? Come back. These letters.
There's his lanyard.
Put it up. Okay.
why is y'all guys' text messages different from what I'm seeing all the time? something different. Like,
Is this already in exhibit?
yes,
Which exhibit is it?
What?
I can't see nothing. I don't know what I'm looking at.
It's not on the screen in front of you? Is it on the screen?
Yeah, I see this, but I don't know.
You see the words?
Yeah.
That's what Mr. Tacopina is requiring.
So on
Words.
the next morning, November 7th, 6:40 a.m., you sent a message saying to John.
No, that's not
I
John.
want it.
That's
Who's
not
that?
John.
Who's that?
That's my business partner.
Well,
So
that's
you're lying.
Justin.
You're lying.
That's Justin.
You know that's Justin. You're not even putting names next to it.
So what you said to him, that same
But
time.
you just lied.
Stop it. Stop it.
Like, what am I
Okay,
having? What am I
who is this
talking
text
to
going
this
to?
man for?
Who is this text being sent
Well,
to?
I do not want to stay here. You put me on. I'm not on trial. I've been here for 5 days dealing with this man. You just said it was a manager. This is not a manager.
Chill.
And I'm ready to go.
Was this text to John or is this to your manager?
This is
your
to my.
partner?
This is my business partner.
Okay, business partner.
So you sent to your business partner
Stop.
at 6:30 a.m. that same morning that you're sending Rocky a message saying you try to kill me, a message saying, I want to get this end's money.
Yes, that's my business partner. He shot me. I have no career.
You were asked by Mr. First Lawman, you saw that videotape of you sitting with Detective Flores and Manfrey. Remember that?
Yes.
And you were asked on page 3 of the transcript, Your Honor, I'm not going to replay it, but we can just go to page 3 of that transcript. Please, please.
You have it?
Yes, sir.
Go on to page three.
No, I'm tired of trying to trip me up.
Just take a
Like,
take a swig.
I'm looking stupid for 5 days.
Stop.
I'm on trial.
Stop. Don't say it.
On page 3,
Throws the
lines
water.
14, 15, and 16, so you look at that, please, Mr. Beckman.
On this?
Yes, on the transcript.
What am I looking at?
Lines 14, 15, and 16. Page 4. So, sir, while you were watching the video with Detective Flores and Detective Manfrey, you said to them, and you see my girl, right? That was my girl I was with. So it's your testimony that as you watched that video, you saw your girl living apartment with you.
Objection, this case is
Sustain. Sustain.
But what did you mean by that? When you
I
said
don't
that?
recall. It was a long time ago.
He doesn't recall. It was a long time ago. Now, I wanted to just remind you guys of how much a train wreck that case was. So if we're gonna have round 2 on a civil trial, buckle up because it's gonna be pretty long. So we know that there's a hearing next week. I'm very curious to see if it's televised. I think it is. It should be a different judge presiding over the civil matter, but we will have an update next week on what happens with that because it could either get tossed out. But if Relli comes back and takes a stand again, and we have to go through this entire trial all over again, and this time Tacopina being named as a defendant, you can see the contention that they have. Is it something that's personal? Or does he genuinely think he has valid defamation claims? I don't think that he does. I mean, I really, truly don't think that he does. But that is the update for all things ASAP Relli. We will be televising, or we will be here for that hearing next week. Next, I wanted to shift over to Kyren, Lacy. This is something that came across my desk. A few of you guys have been asking for us to cover it. I am very new to this particular case, but there was supposed to be a trial before this young man took his own life, so that was pretty tough. But now we have body cam footage that shows the full incident, and this was released by the Louisiana State Police. So for those that are unaware, Let's take a look at this car crash. What happened? Because this is a former NFL player, and this was the incident that was released by the police. Let's take a peek.
I'm Colonel Robert Hodges, Superintendent of Louisiana State Police. You're about to view a critical incident briefing video that is intended to give the community a better understanding of the incident that occurred. The video is inclusive of evidence related to the incident, which may include 911 calls, body-worn camera footage, and other relevant information. As this comprehensive investigation develops, our understanding of the incident may change as additional evidence is collected, analyzed, and reviewed. The Department's ability to investigate these incidents relies on the impartial and transparent investigations, as well as considering the potential criminal responsibility of those involved.
On Tuesday, December 17, 2024, Louisiana State Police Troop C began investigating a fatal crash that occurred on LA 20 near Perez Lane and Chack Bay, located in Lafourche Parish. This investigative briefing has been prepared to provide clarification of the facts and an accurate depiction of the evidence in the moments leading up to the crash and the subsequent investigation. Due to differences in technology, the timestamps on the business surveillance footage may not align with the actual time data recorded by Louisiana State Police based on recorded radio communications. According to the video timestamp, at 12:03 p.m. and 52 seconds, a green Dodge Charger is seen traveling south in the opposing lane on LA 20 at a high rate of speed, passing 3 passenger vehicles and 1 loaded 18-wheeler in a designated no passing zone with a 40-mile-per-hour posted speed limit. As the green Dodge Charger returns to the southbound lane, aggressive braking and engine deceleration are immediately followed by a crash that can be heard on the surveillance footage.
Yeah, that is definitely high speed. Someone died.
According to the video timestamp, at 12:03 p.m. and 54 seconds, a portion of the crash can be seen as it occurs. Moments before the crash, the gold pickup truck abruptly veers out of the northbound lane into a business, while the green Charger is approaching in the same lane. Immediately after the crash occurred, the green Charger was observed on surveillance video and by witnesses traveling through the crash scene and continues north on LA 20, failing to stop. At the same time, all other vehicles remain at the scene to provide assistance. The briefing will now transition to the troopers' response and investigation. At 12 o'clock p.m., a 2-vehicle injury crash with road blockage was dispatched to Louisiana State Police Troop C via the 911 dispatch system. The responding trooper arrived on the scene at 12:07 p.m. and was immediately met by numerous witnesses who described a green Charger driving aggressively and causing the crash. The video has been edited for time purposes.
Region 2, be advised, we got total road blockage on LA 20.
If you get a chance, can you advise code of injury?
Civil.
It's a natural instinct to turn and then she had no choice. Head on.
Did you see a green Charger flying that way? A green Charger that going that way?
There was a green Charger.
There was a green Charger
that caused all this.
SRT8, he caused all of it. He went to pass the cars way back there, sir.
Wow, look at that.
The green Charger collided with these cars? He went right between.
He went around that truck, okay?
He was passing up with
her right now, and she had no choice. She hits the pole, she gets this.
How are the injuries?
She got a broken ankle.
And two are complaining about back injuries and then stuff like that.
Yeah.
I was on the phone when
two back injuries, one broken ankle?
Yeah,
I'm not exactly. I just told him not to move. You know what I'm saying? You said something about a green Charger. Who told you something about a green Charger? I'm down 18 wheeler like this, sir. Okay, so you saw it. So what did you see happen? He went to pass him.
I'll say when he went to pass me cars back there around around the curve, all right?
Okay.
All right. Hey, he come down, right? When he come down, I got Mr. He had his brother that he was taken to the emergency room, to the hospital or something like that, chemo or something like that. But I got his number also to verify this, because he was the car that was in front of her. When that green Charger came, he went caused this whole big traffic, so everybody went to hitting brakes because the Charger, I thought he was hitting the gold truck head on. So he jammed on brakes. She was coming down, they was going that way. When I saw...
Which way was the Charger going? The Charger
going this way.
Charger's going this way, okay.
She was coming this way.
Okay.
They was going this way also. Mr. jammed on brakes. She went to dodge Mr. And that's when she came on.
I was about to gas
hit him, on the left side. She come over and hit him.
Which 18-wheeler were you driving?
The Rebel.
Okay. So the Charger, I guess, passed you up?
The Charger beeline, it was cars behind me because I'm taking my time.
And the Charger passing all these cars in this
everybody.
lane? And so almost hit this one head on?
No, he almost hit this. It was a gold truck. I got his number right here. That's why I took his number and his name.
Almost hit the gold truck head on?
Yeah, that's his number and phone number and name.
So the gold truck, what did the gold truck do?
The gold truck in his area right here.
The gold truck slams on his brakes.
Slams on brakes to stop the Charger. The Charger swerves back in.
Okay.
Cut somebody else off, whoever was behind them.
Okay.
But then they slammed. They was the Charger. He swerved in front of them. They slammed on brakes, and by this time, Mr. he slips through, right?
Okay.
As he slips through, she's coming. She like to ram the back of the gold truck. That's what I'm saying.
She almost hit the back of Miss.
Yeah, Mr.
Was Miss truck hit?
No. He was missed.
Okay. So the truck, Mr. He slammed on it.
In other words, it was right up. The gold truck was right up there.
Right. Yeah. He slams on his brakes to avoid the Charger.
Yeah.
This car, what?
Cuts that car off, if I'm not mistaken.
So what does this car do? It just swerves out the way to avoid.
Because I was watching it too.
She turned the wrong way. Yeah. Instead of going towards the post, she turned this way.
Yeah. Okay, so she turned this way, and then this car was just coming.
Yeah.
I got you.
Yeah.
I got you.
Yeah. And then the Charger came around.
That's the number for the guy that was in the gold truck.
Okay.
Charger passed in between the mailbox and the car.
Stopped.
I took that because he was leaving, but
Okay.
And see what happened, the Charger had stopped.
Is a green Charger?
Yeah. But then when he seen what happened, he almost hit me because he came right here and kept going.
He was the only one that that jumped out of the traffic. Everybody else turned around went the other way. He jumped out of traffic, eased through here, and went on down the road.
Okay. Okay. Look, I know it's hurting right now, but do you think you could just tell me briefly what happened? Or do you remember?
I just know the truck was stopping on brakes. The other car was trying to pass the other car. I was trying to dodge, but not hitting anybody coming around.
Okay. Do you remember how fast you were going?
The speed limit.
Yeah.
Okay.
39.
Thank you.
While on scene, the investigating trooper obtained written and recorded statements. The trooper also spoke with additional witnesses via phone and ultimately obtained written statements later in the investigation. After the crash, the passenger in the Kia Sorento died. As part of the continued investigation, the investigating trooper made contact with the driver of the gold truck at a later date to obtain an official written statement based on previous conversations. Troopers also received an additional witness statement describing the erratic driving behavior of the green Charger 10 minutes before the crash. Following the on-scene investigation, troopers identified the green Charger as a vehicle of interest and utilized 21 separate surveillance video cameras to capture the uninterrupted path of the green Charger from the crash scene to its Thibodeau business 11 miles away. Through the use of investigative tools, troopers were able to obtain the license plate number of the green Charger on December 19th, 2024. On December 26, 2024, troopers determined that Kyren Lacy was the driver of the green Charger at the time of the crash. Just prior to the crash, Lacy was illegally in the opposing lane, passing southbound vehicles. The gold truck traveling north veered right to avoid a head-on collision with the green Charger. As the gold truck veered right, the driver of the Kia Cadenza saw the approaching green Charger. In reaction, the Kia Cadenza driver swerved left into the southbound lane and impacted a northbound Kia Sorento. Through the investigation, troopers determined that the driver of the gold truck reacted appropriately to avoid a head-on collision with the green Charger, which was approaching at a high rate of speed. In consideration of the high speed of the green Charger compared to the surrounding and opposing vehicles, the reaction time of the involved drivers was greatly diminished. Since the incident occurred, the Louisiana State Police never reported that the green Charger impacted any of the involved vehicles. However, all evidence collected supports the conclusion that Lacy's reckless operation of the green Charger in oncoming traffic triggered the chain of events involving the other drivers, ultimately resulting in the fatal crash. Additionally, troopers determined that less than 10 minutes after the crash occurred, evidence supports that Lacy's first outgoing phone call was to a Baton Rouge area personal injury and defense attorney.
Wow.
After consultation with the Lafourche Parish District Attorney's Office on January 2, 2025, an arrest warrant was signed on January 8, 2025 through the 17th Judicial Court for Kyren Lacy. In coordination with his attorney, Lacy was arrested on January 12, 2025 at the Lafourche Parish Correctional Center.
Let's break down those charges because this video is about to end, but it looks like he had one count of negligent homicide. That's a felony. One count of reckless operation of a vehicle. That's a misdemeanor. The next count was a hit and run through driving, and that's a felony.
The driver of the Kia Cadenza was initially issued a citation for following too close, which was later amended to driving left of center. This incident resulted in numerous injuries and loss of life. All involved victims deserve a thorough and complete investigation based on all available factual evidence. Additional investigative reports and videos can be utilized through the Trending Topics link on the GovQA platform.
So this is a tough one, guys, and shout out to Brandon who mentions that he has gone to the school, an LSU alum. So, you know, it's a popular case, but at the same time, it's also super tragic for all the people that lost their lives, including, you know, the person that was involved in the accident. It's a tough way to go, you know, car accident. And then on top of that, you know, Kyren, you know, took his own life. So, you know, it's a lot of pressure here. We're watching it. It's a new case to me, but I am seeing it trending. So we're keeping an eye on it throughout the week. And we'll go from there. But that has emerged as the state police want to be transparent, and they released everything that they found as they were investigating this case, right? So we're going to keep an eye on this one. It's definitely heartbreaking. And, you know, again, you know, you want justice for people, but you want justice for people in the right ways, right? And imagine if he is, you know, because some people are saying that there is new information that has been released that he may not have been liable. Again, I got to dig into it before I put it in front of you guys, but because that came from the state police, I wanted to show you and also just have a quick discussion on it. So that's the evidence in that one. ASAP Relli, I mean, come on, really. I don't know if that case is even going to make it to January, but it is going to be busy. So as mentioned, guys, we are back tomorrow for Donna Adelson's sentencing. It's at 3 p.m. Eastern. I've already scheduled that live stream. Courtney Clenny has a hearing on Wednesday, so we're likely going to cover that one as well. Power hours are at 12 o'clock Eastern on Tuesdays and Thursdays. So I'm going to pretty much be here all week live streaming. So definitely want to make sure that we cover all these things and keep you guys up to speed post Vid Summit. And, you know, we just posted a video on Karen Reed's case as well. I think her next hearing is mid-November. The next big case that we have is Courtney Clenny, and that is scheduled for December 1st. So I'm watching all of these things, trying to keep my eyes on all these cases, but definitely wanted to make sure that we covered this one. Anywho, I'm going to pop on out of here. Before I do, I did see one Cash App come through. Shout out to Real Talk with Retta. She sends me a $10 Cash App. Thank you so much. She says, I'm so proud of the success of your channel. Love ya. Yes. So Vid Summit was huge, guys. I was able to teach a class. I had, it was a workshop that had, you know, it's just about 50 seats, and I had 72 people register. I think it was like 80. So we had a full house. It is recorded. I don't have those clips yet, but as soon as they're available, I will share them. Vid Summit is it's a YouTube driven conference. So I was there down in Dallas last week teaching a course. I met so many talented creators, did meet Legal Eagle. So if you haven't seen that, that is on my community tab. Very, very cool person, made some contacts at Law and Crime. So I got you guys, but it is fantastic. All right, we are going to jump on out of here. I hope you guys enjoy the rest of your Sunday. We'll be back tomorrow for Donna's sentencing at 3. Stay safe out there. See you in the next one. Bye.